Hello, a warm welcome to you whether you're watching live or whether you're watching later. For those of you that don't know me, my name's Ben Handy. I'm a member of St John's Personal Injury and Clinical Negligence teams, and I have the pleasure of introducing this, the first of our free live webinars. We're very conscious that for many of our instructing solicitors right now, training budgets are restricted, and with that in mind, these sessions, absolutely free, are going to be a regular fixture over the coming weeks and months. The idea is that you can stay up to date with some of the developing issues and fill your CPD quota at the same time. It's going to be a varied programme, and we hope that within it you will find much that interests you. I have the easy bit. This afternoon you're going to hear from my friends and colleagues James Hughes and James Marwick. They'll be talking about the recent amendments to the CPR and practice and procedure during this pandemic. We'll be talking for about 15 minutes each, so if you don't want to listen to me, now will be the time to make a cuppa. We won't be able to hear you, unfortunately. It will be unworkable to work that way, but there is a live Q&A function in which you can post any questions you may have for us. If you look for the icon with the speech bubbles and the question mark, you can then type your questions. We'll see them as you send them, and there'll be a Q&A at the end, during which we'll answer as many of those as we can. I'd normally start any seminar by pointing out the location of the food, the drink and the fire escapes. But given that you're watching this from the comfort of your own homes, I'm afraid you're going to have to work out that for yourselves wherever you are. Instead, I'll thank our marketing team, Emily and Hannah, who have put in a huge amount of hard work to get this programme set up and are even now sitting behind the scenes managing production. They've asked me to remind you to follow us on Twitter and LinkedIn for all live and up-to-date information on upcoming webinars and news stories. You will find details of how to do this and all of the relevant links and contact details for the things I will go on to mention in the next few minutes in a follow-up email that you'll receive afterwards. Before I introduce James Hughes, I want to talk to you briefly about instructing St John's electronically. There's a huge amount I could talk to you about in this regard, but I want to limit it to the main issues, that is instructing us for written work or oral advocacy, and making the most of the services we can provide for you outside of that. We've all had to adapt a great deal over the last few weeks and months. Some of us had been working electronically to a greater or lesser extent before lockdown, but the world in which we now find ourselves suddenly requires it. I'm sure I'm never going to get used to watching my own face, God forbid hearing my own voice in playback, but these are things we're all going to have to deal with. And the first and overarching point I need to make for you is this. St John's will do whatever we can to make life easy for you. We've had to move to a system of accepting instructions electronically, and we are all getting used to seeing each other through computer screens. But please remember that behind the screens, we still have our wonderful team of clerks in Annette, Adam, Hugh, Lara and Abigail, who remain willing to bend over backwards and assist you if you have any difficulty. We also have some big news of a major development in the way Chambers is working in order to make things easier at your end. Now that our members are working remotely from home, we are moving to a completely remote system, built and based around Dropbox for Business. It is secure and fully GDPR compliant. As our Chief Executive Derek said to me the other day, it's designed to be an easy way to perform a clean drop, moving files straight from your secure system to our secure system without any intermediate step. If I share my screen with you for a moment, I can talk you briefly through what will happen in future when you send us instructions. In the usual way, our clerks will create a new case on the system. That will automatically create a shared folder in Dropbox to which the clerks and the instructed barristers will have access from whatever remote locations and on whatever machines they're all working from. At the same instant, you will get a short acknowledgement email which will include a link allowing you to upload files to this shared folder. My clerk Hughes helpfully set up this test folder for us here. Using the link that you're provided with, you can immediately send counsel any document from your system by simply dragging and dropping it into the shared folder. Whenever you do that, counsel and the clerks will be notified that new instructions have arrived in the shared folder and take appropriate action. From my perspective as the barrister, I will simply see this, a folder on my computer that will be instantaneously filled with whatever documents you have sent in. I can take those documents, work on them, do whatever I need to do and return to you. From your perspective as instructing solicitors, you will find pretty quickly, we hope, that this is much easier than sending papers to us by email. So if I cancel my shared screen there, and hopefully it will come back to me. There are other neat features. If another barrister in chambers becomes involved in the case, whether as a junior or a leader, or because they're covering a hearing for you while your preferred counsel is unavailable, they can be granted access by the clerks to the shared folder, and therefore all of the relevant papers you have provided by the simple click of a button. This new system is incredibly fluid, and our developers can go on adjusting it to suit our needs and yours. One adaptation we're already considering is a system whereby counsel can upload any documents they have drafted to the shared folder, and you will get a notification they have done so and can access them there. It's a movable feast, it's moldable, but at its heart is a system that is secure, instantaneous, and we hope painless. No doubt other ideas for improvements will present themselves as we go along, and we'll be interested to hear your feedback once you've had a chance to work with it. I need to emphasise that this system is permissive rather than restrictive. If you have a different system, or you want to send us papers by email, or a secure system of your own, that is no problem. We can work that way still. This doesn't restrict you. Instead, we hope it opens up a new, even easier way of working with us and more direct access to counsel. Written work aside, of course, the other key services we provide are remote hearings and video conferencing. We will have at least one video hearing for you in the coming weeks, probably more. You've very likely seen plenty of mock hearings and proof of concept out there. We know this can be done, and you may have heard that the courts have developed their own video conferencing software. Emma Zeb has done an article on this, which is on our website, and I'm sure James Marwick will be talking to you about that in a bit more detail later. So of course, it seems likely that video hearings will now start to happen more and more. We are set up for that, and we are ready to go as soon as the courts are. But what we want to offer you in the meantime is this. Rather than just watching a mock video hearing, you or your team may feel that actively being involved in one might be a valuable experience. When you're talking to clients about such hearings and they're nervous about how they might work, you will be able to reassure them that you know what it feels like because you've done it. If this sounds helpful, please get in touch with us and let us know. We will set one up for you and your team. Rest assured it'll be private, it won't be broadcast to the nation unless, perversely, you want it to be. For conferencing, our preferred software is MS Teams, but like us, you'll probably have become aware that using any and all of the mainstream software follows a similar pattern. You don't typically have to be signed up or to have downloaded the software to join a call. You're typically just sent a link and you join it by clicking the link. So the software you use and we use is frankly a movable feast. The only essential is, of course, that all parties to the call have a functioning internet connection and appropriate hardware, although frankly even that can be a smartphone at a push. If you need our help, ask. I have set up a couple of video conferences in the last week or two, and all I needed was an email address for the people, witnesses, clients, experts, solicitors who were joining the call. But with this way of working, e-bundles are becoming all important. You're all used to preparing bundles for trial, of course, but for video conferences, it is also now essential that everyone has the same thing in an ordered, navigable format. I would say then that good practice now is to prepare paginated bundles, if you can, for any video conference as well as hearings. If someone's missing the odd document, you can still work around that by sharing your screen, but frankly, it only seems to work for the odd document. More than that, I think, would be difficult. So more than anything else, perhaps, making sure you get the right documents to the right people in a workable format has become essential. And while counsel, of course, will work around any formatting issues, you might find that lay clients, witnesses, heaven forbid, judges, just don't have the resources, time, or possibly the will to get into those documents that aren't easy to open. So for my part, having worked paperlessly for about a year, I would say this. Use PDFs where you can and use as few PDFs as possible. They're adaptable, they're editable, they can be merged, subdivided, drawn on, rotated, flipped, basically anything you want. Most importantly, they open on every kind of hardware and software, and they can be paginated. Word and Excel are fine, they also open on everything, and of course, they have the ability to edit those and send them to court or back to you if they need to be edited. Thankfully, I found that photos, audio recordings and videos seem to work very well with almost all of the latest software. As long as they're sent digitally, as opposed to by disk, then my experience is that they'll open and they'll work. Disks are, of course, the devil's work and seem hell-bent on refusing to work on any machine that I try and put them in. The only thing I would say is that, as a Mac user certainly, .msg files are the enemy. Those are typically email chains or historic emails with numerous attachments. They are very difficult to work with. They don't open neatly, they're often full of repetition, and most importantly, the attachments to these emails can't be opened without a fair bit of effort. So I would suggest, as I say, PDFs, possibly Word, and I expect in the end you will find yourself sending everything in that form to counsel, judge, experts and clients. The fewer attachments you can send and the fewer different formats you can send them in, the less chance there is for error. If you need a hand converting bundles or documents to put to PDF, putting together pagination, anything you think we can help with, please do contact us. Christopher Sharp QC has done a useful article on this, which you'll find on our website. Finally, I've got a reminder of 3 other services that Chambers is offering. You may already be aware of our fast track mediation service. Within the department, we have a number of accredited mediators ready to assist with the settlement of disputes that might otherwise, in the current circumstances, be kicked into the long grass for many months or possibly even years while the courts play catch up. So bear that in mind. For that reason alone, cases which may not previously have been suitable for mediation might now be appropriate candidates. We also have a free dedicated personal injury hotline if you have any procedural or tactical problems you want to run by us. The members of the PI and ClinNeg team share the responsibility for that between us, so that one or other of us is manning the phones at all times. If you imagine one of those big celebrity fundraising phone-ins from the 90s that you used to see on the telly, you probably aren't far wrong. If people were lucky in those days, they'd get Melinda Messenger or Bob Monkhouse. If you're lucky with ours, you'll get Emma Zeb or Christopher Sharp QC. Those aren't direct comparisons. We also want to remind you that if you require any bespoke training or seminars on any particular issue, please do get in touch with us. It may be that you want to be directly involved in a mock remote hearing, as I said before. It may be that something particular to your practice area that's only touched upon in one of our regular talks and on which you would appreciate a bit more detail. If you think of something or your interest is aroused by something you hear, then please get in touch with us. We're here to help, so use us. All of the relevant links, email addresses, contact details and so on will follow shortly. So let me just finish by saying this. Even when we go back to doing in-person hearings and conferences, we can probably expect the courts to use technology more readily in future. And of course, they will expect legal representatives to assist. St. John's will be here to help you in any way we can. We hope that with our new Dropbox system, our video conferencing software, our remote fast track mediation service, our free advice hotline, this series of webinars and the offer of bespoke training, we have in place a system that can give you all the support you need. I will thank you and hand you over to James Hughes, who will take you through the recent amendments to the CPR. There is a chance that if you come back to me during the Q&A, I'm being mauled by the dog. He's been brilliant, but I can hear he's just starting to stir. Thanks.
Thank you, Ben. Good afternoon, all. I am, as Ben has said, and I'm just going to share my screen with you, my PowerPoint slides, talk to you about recent amendments to and updates to the CPR. These changes came into force variously at the end of last month and the beginning of this month, so they're in force now, and I'm going to tell you in at or about 20 minutes what you need to know as far as personal injury in particular, but clinical negligence work alongside that in general is also concerned. So there's 6 topics I want to focus on. They are the amendments to entry of default judgment, disclosure of Part 36 offers on appeal. For completeness sake, you'll see from this second slide, and these slides will be available to you. Emily and Hannah are going to be able to send them round to you once we're done this afternoon, but there have been various amendments to the media and communications rules, housing matters, and in respect of final charging orders from legal advisors. I won't trouble you with those, but you can have a look at them yourselves if they're of any interest. I am going to focus on amendments to certain of the practice directions, specifically rules pertaining to credit hire, in respect of statements of truth and the declaration as to witness statement translation. The practice direction part 44 in respect of costs and mixed claims and those found to be fundamentally dishonest. And finally, routes of appeal. So to the CPR first and default judgment, paragraph or rule 12.3, I should say, has changed the time limits in respect of applications for default judgment. So far as relevant, I'll read you out what the rule now says. The claimant may obtain judgment in default of an acknowledgement of service only if the defendant has not filed an acknowledgement of service or defence to the claim or any part of the claim, and the relevant time limit for doing so has expired. And judgment in default of a defence may be obtained only where an acknowledgement of service has been filed but a defence hasn't been filed, and in a counterclaim under Rule 20.4 where a defence has not been filed. But the emphasis here, it seems to me, is and in either case the relevant time limit for doing so has expired. So what does that mean in practice? I think it clarifies a number of things. I think, practically speaking, it is helpful to a defendant who hasn't acknowledged service for whatever reason they might not do, but then chooses to or comes to its senses sufficiently in time to file a defence. Judgment in default, it seems to me, is at the top of the defence, I should say, is now exactly that. And the claimant now has to wait until a defence doesn't come in after acknowledgement of service has been filed for judgment in default of a defence. What do I think is the other practical implication of that? Well, I'd hope that this is going to mean fewer applications either made by claimants or contested by defendants for default judgment, because a claimant has to wait until the time limit for filing an acknowledgement of service and or the defence, if the defence is missed, but the acknowledgement of service is not, has passed. Part 36 offers on appeal. Paragraph 22 of Rule 52, and I think that also bears a close reading, so I'll read it out to you. It says, or now says, the fact that a Part 36 offer or payment to the court has been made must not be disclosed to any judge of the appeal court who is to hear or determine an application for permission to appeal or an appeal, but until all questions other than costs have been determined. So the appeal judge now has the power to determine as a separate issue by a separate hearing, if he or she wants to, the costs of an appeal. Paragraph 1, however, doesn't apply if the Part 36 offer or payment into court is relevant to the substance of the appeal. So if the appeal is about a question of costs or a Part 36 offer itself. Importantly, it seems to me, paragraph 1 doesn't prevent disclosure in any application in the appeal proceedings if disclosure of the fact that that offer or payment into court has been made is properly relevant to the matter to be decided. And some important observations on which effectively form part of the rule have been added in by the amendment. It says that Rule 36.4, that's a Part 36, has the effect that a Part 36 offer made in proceedings at first instance won't have consequences in any appeal proceedings. I think this is the nub of it all in terms of practical points here for us. A fresh Part 36 offer needs to be made in appeal proceedings. But, however, this rule applies to a Part 36 offer whether made in the original proceedings or in the appeal. So what does all of that mean? It seems to me that an appeal judge can now consider a Part 36 offer in respect of both, in my view, the appeal and the first instance proceedings, but the fresh, that is the Part 36 offer, which is made in respect of the appeal, will have an effect on the costs of the appeal. And so that's why I think Rule 36.4 and the interplay with the amendment to the rules on Part 36 offers in appeals is important. But it would seem to me that the word however in the addition to, which effectively forms, in my view, part of the rule itself, will allow the judge presumably to consider a Part 36 offer made below. And I think that those amendments have, would encourage the making of fresh Part 36 offers in any appeal. Credit hire, and you'll forgive the bold type at the beginning of the slide. That is there in error. It doesn't necessarily suggest that those words are any particular importance. What is important, if this is an area of practice that you do, and if it isn't, apologies, but there have been amendments to Practice Direction 16, that is the rules dealing with how statements of case ought to be, relating specifically now to what needs to be pleaded in credit hire cases. And those are at paragraph 6.3 of the Practice Direction of Part 16. And they are these: the need for the replacement vehicle at the relevant time. And these are mandatory requirements. You'll see paragraph 6.3 says the claimant must state in the particulars of claim. And the period of hire claimed, providing the start and end of the period, the rate of hire claimed. Importantly now, albeit my view is that there's probably going to be some scope for argument about what the reasonableness of the period and rate of hire means, but there you go, you've got to put that the period was reasonable and that the rate at which you hired was reasonable, and impecuniosity if the claim is for credit hire. And paragraph 6.3, relevant time is defined as meaning at the start of the hire and throughout the period of hire. So the burden's now on the claimant to plead and prove that they had a need for the vehicle which they hired throughout the period of hire, not just at the beginning, at the end. There is also now a requirement to plead relevant facts. And this is, again, my view, but it seems to me there that the obligation is now on the claimant to plead specific facts as to the need and reasonableness of the need for and reasonableness of the credit hire vehicle throughout the period of hire. And you've also now got to plead as a claimant expenses spent in mitigation of loss or damage. Or I should say mitigation expenditure. So I think that adds some clarity here, and probably a little bit more certainty for defendants to these claims. A claimant's got to set out their stall from the get-go now, as far as a need throughout the period of hire, exactly how long it was hired for, what the daily rate of hire was, and why it was reasonable. As I said, that might, it would seem to me, at least from a claimant's perspective, appear to be either a little bit woolly, that is the definition of what's reasonable or reasonableness here, or probably more likely self-serving, because if the rules now say as they do that the claimant has to plead that the need for and across the period of hire that there was a reasonable need for that vehicle, it all sounds a little bit self-serving to me. But those things being so, and now with the requirement that the obligation that a claimant has to plead mitigation expenditure, and so that's anything spent to mitigate loss, whether those are salvage costs, repair, anything which is always likely to decrease the defendant's liability. I think defendants can look on these amendments, it would seem to me, in my view, as a way of clarifying and helping exactly what claim they are going to meet, and also to clarify exactly what points a defendant wants to take to attack the claim for hire. Statements of truth. Some of you may have already seen these from your particulars of claim and your other statements of case. These amendments came in along with the new requirements in respect of translation of witness statements at the end of last month. And there's been a change of emphasis in the form and content of the new statement of truth. And so paragraph 2.1 to the practice direction to part 22 now says, or the statement of truth now reads as follows: I understand that proceedings for contempt of court may be brought against anyone who makes or causes to be made a false statement in a document verified by a statement of truth without an honest belief in its truth. And as far as paragraph 2.2 is concerned, there's an emphasis now on the statement being provided in the language, that is the statement of truth being provided in the language of the witness statement itself. And again, the addition of the understanding on behalf of the witness that they may be subject to proceedings for contempt if they're found to have made a false statement in that witness statement. As far as translation is concerned, as I've said, the statement of truth must be in the witness's own language, and it must be dated with the date on which it was signed. If there's a need for an interpreter, paragraph 3.82 of the practice directions to paragraph 22, or part 22 I should say, now includes the need to clarify whether an interpreter is needed or not. And you also now have to clarify whether the witness was unable to, whether by reasons other than by reason of language alone, to read or sign documents to be verified by a statement of truth. So I think that puts a clear focus on the potential for false statements being given to give rise to contempt proceedings, and you'll see here, at least what's very clear to me from that amendment is that there is a clear link between those provisions, or the new wording of the statement of truth, and fundamental dishonesty and disapplication of quoques, because a finding of fundamental dishonesty will usually be at least a decent springboard for a defendant to, and its insurer, or the defendant insurer, to be thinking about contempt proceedings. As far as practical points to consider, in my view, for the amendments to the language of the witness statement and the statement of truth, it makes clear at an earlier stage the need for an interpreter, whether an interpreter is going to be needed or not to assist that witness give evidence, and or for problems of credibility. I think problems can arise, we will know, at trials where the witness who may not have signed the statement, or may not, or the witness may not have as good a command of English as has the person who has signed the statement, who's translated it for them. And so that can give rise to questions of credibility. There may also be questions of credibility if that person, the witness, hasn't signed the statement his or herself. I think these amendments will allow the parties to identify those potential problems at an earlier stage. And it seems to me that there's an interlink between the two, because the amendment to the statement of truth applies equally to the translation provisions. Costs and mixed claims. So the Court of Appeal, in the decision of Brown and the Metropolitan Police Commissioners, you may have heard about it, or you read it yourself, was decided towards the end of last year. And the claimant, Miss Brown, in that case, sued the Met Police in a mixed claim, what the Court of Appeal say commonly is described as a mixed claim, which is where there's an element of personal injury alongside other damages sought. I'm jumping a slide ahead here, but that's just to give you an idea about what was going on in the Brown case. Part 44.16, you will know, are the fundamental dishonesty provisions and the disapplication of Quox provisions. And those provisions provide that if a claimant or a person on whose behalf the claim has been brought is found to have been fundamentally dishonest, that is, the person other than the claimant for whose financial benefit the claim was made, then the qualified one-way cost-shifting protection that the claimant enjoys if they are unsuccessful, or if they are successful to the extent that Quox limits the amount of costs they're liable to pay, doesn't apply. And you can see there the wording. It's I've always found it a bit of a slightly clumsy wording, the Quox provisions in the FD rule, but there we go. But the essence of the amendment is now that the claimant or the person for whose benefit the claim was advanced, I put there in brackets a protected party. I don't probably worded that in a little bit of an unclear way. A protected party is an example of one of the people for whose benefit the claim can be advanced. But the point now is that if there is a finding of fundamental dishonesty, then those parties will be liable to foot the successful defendant or party alleging fundamental dishonesty's bill of costs, even if that amount of costs exceeds the amount of damages which the claimant recovered in a successful claim. And as I've said, Miss Brown, she sued the Met Police Commissioner for personal injury and, amongst other things, a misuse by the Met of her private information. The PI claim failed. The misuse of private information claim succeeded. The defendant had made a Part 36 offer. Miss Brown, the claimant, didn't beat it. The Court of Appeal held that in that mixed claim, Quox didn't protect her. And to the extent that the previously worded version of paragraph 12.6 of the practice direction, which has now been amended, could be understood differently, the Court of Appeal said, well, that needs an immediate change. It's also worth reading the judgment to give you an idea about what the Court of Appeal thought personal injury claims were. They were careful, though, however, to say that Quox does apply to mixed claims where there hasn't been a finding of fundamental dishonesty, I should say, as I read the judgment, or the claimant hasn't not beaten a defendant's Part 36 offer. So that leaves us now just with routes of appeal. And the essence of these amendments, it seems to me, are twofold: that where an appeal is from the county court or to the High Court or within the county court, any judge who has the power to hear the appeal can hear the appeal itself and any application within it other than a permission hearing. And these amendments open up the class of judge who can hear such appeals, whether within the county court or from the county court to the High Court. And Group C judges, so those judges with Section 9 tickets, also have that power now. It seems to me that this is opening up the class of judges who as I've said, who can hear such appeals. I think it also means the end of rolled-up hearings now, because on that rewording, it looks like a different judge will have to hear the application for permission. So practically speaking, it may give you cause to think about, having had success in the permission hearing, you might have to think about, in practical terms, if you're going to get a different judge, whether you might have a different outcome in the appeal in light of the Part 36 offers on appeal, which I've talked to you about previously. I've just seen as well, that's my 20 minutes up. Save us to say that there were also the 114th and the 115th amendments to the CPR. I haven't talked about those because they were in respect to the online civil money claims pilot and the video hearing pilots. You can have a look at those for yourself, but those are ongoing schemes, and they may be of some interest given what James Marwick is now going to talk to you about. Thank you for listening to me, which is the practical considerations. I'll just stop sharing my screen. Practical considerations in the time of the COVID-19 pandemic. So I shall hand you over to James, and as I say, thank you very much for listening to me.
Hi all, and thank you very much for joining me. Last but hopefully not least, I'm going to talk about COVID-19 practice and procedure. I'm going to focus in particular on remote hearings and then some of the amendments to the rules which have been introduced in relation to both extensions and remote hearings as well, before focusing on some of the other miscellaneous matters which arise in light of the pandemic. My talk comes with two health warnings. The first is this: the operational guidance and practice is constantly being updated. I prepared this PowerPoint at the start of last week and I had to amend most of it this morning. The second health warning is, to the extent there is operational guidance, it appears to be being applied inconsistently throughout the courts. What we're going to do is go through some of the overriding guidance as well as look at some of the local practices, particularly in the Western Circuit. I'm going to share my screen now, if only anything, so you can hide the haircut I had yesterday, which was a bit more extreme than I hoped. And if I go to beginning of slide screen, what I've done on the first PowerPoint is set out some of the resources which contain a summary of the guidance, and they're updated day to day. So this is a very helpful starting point if you are wanting to look at what is the present state of play in terms of HM, courts and tribunal service guidance in relation to the operation of both remote hearings in the courts generally. I think, as James said, I think the PowerPoints ought to be available, but if you're struggling in any way to access any of the links, please don't hesitate to drop me an email and I can forward them on. To give an idea of where we're at, I've just taken a snapshot of what the civil court listing priorities are as at today. And it's divided into two tranches. Priority one, work that must be done, and there's some unsurprising types of work included in priority one, but not least at the bottom, all multi-track hearings where parties agree that it's urgent, subject to triage, as well as applications in cases listed for the next 3 months. So in theory, multi-track hearings and applications relating to them have been prioritised if urgent. Priority two, work that could be done, and actually, in terms of personal injury and clinical negligence work, includes a lot of the everyday work we might encounter. So, for example, from Part 21 approvals, where it said children could attend by Skype, through to stage 3 assessment of damages, and right down at the third up from the bottom, all small claims and fast track trials where the parties agree it is urgent, subject to triage. What is interesting, though, is that this doesn't necessarily reflect how things work in practice. So, for example, I know that, say, Blackwood County Court in Wales, which is a hotbed of stage 3s for various reasons, I think unilaterally pulled most of its stage 3s for the near future. But insofar as you would like to have an understanding of whether your application or your trial is a priority one or a priority two, this is the starting point. But I don't think it necessarily reflects how things are working in practice. If I just go back to the first screenshot, so that's hidden behind the very first link at the top there, daily operational summary on courts and tribunals during coronavirus COVID-19 outbreak. That will take you to the civil court listing priorities. It will also take you to further links which set out, for example, Queen's Bench Division guidance as to how the Masters approaching work. It will also take you to an updated summary of which courts remain open and for what type of work. So I think just on Friday, there were some changes in relation to which courts remain open and not open, even for remote hearings. The next link down, telephone and video hearings. So remote hearings in the time of Corona. And I'm just going to go forwards to remote hearings here. Now, interestingly, the default position obviously is that the civil courts will operate remotely. The use of cloud video platforms, Skype for Business and similar technology is to become the norm. Now, actually, when a lot of the initial guidance was issued, it referred to potential alternative technologies such as Zoom and WhatsApp even. I actually deleted those from my PowerPoint because there was updated guidance given by the court on Friday, which identified that the default remote platforms would be the court's own cloud video platform or Skype for Business. And actually that the court wasn't geared up to use any other technology, for example, Zoom. And actually, if you follow the links to the guidance through, it will tell you practical points on how you enter a call. So the general rule is that the court sets up the call. If it's Skype for Business, you do not need a subscription. You do need an app called Free Skype Meetings. You're emailed a link by the court and you join as a guest. So all fairly intuitive in theory. And I know colleagues who are meant to have trials and who've had applications by video link have said it's gone relatively smoothly. I mean, I've in fact got back-to-back trials on Thursday and Friday, which are due to take place by video link. One's a fairly involved fast track with dishonesty allegations. So I'll come on to that as to the suitability for remote hearings, but for those sorts of issues. But at this time, I haven't actually personally done a video hearing. There are no others have, and the sense it's gone relatively smoothly. Now, in terms of the cloud video platform, this isn't something I'd heard of before Friday. It uses something called Kinley video conferencing. And again, if you follow those links that I set out on the first PowerPoint, it tells you that you can access it through any laptop or video device. So you don't need any bespoke technology, such as, for example, the Skype Meetings app. And you do need Google Chrome. You're sent an email link and you join in. Now, so I thought I was being quietly confident in telling you, look, we've got a bit of clarity as to what platforms are going to be used. But I hope everyone forgive me. I've just had an email in from via Weston-super-Mare County Court, which says this, and forgive me for reading out verbatim. It's for an upcoming trial. The matter will proceed by video conference. The parties shall liaise to make the arrangements by an appropriate provider, probably Zoom. The claimant shall email the judge 30 minutes before the hearing with a link to the meeting and the meeting codes. The Zoom meeting, assuming Zoom is used, must have link enabled to LYNC enabled to allow connection by Skype. The claimant's solicitor shall be responsible for ensuring the conference is recorded via the video application in the file provided thereafter to the court. Now, my understanding is generally the court's been seized with organisers, and what you'd have to do is provide phone numbers and emails for all your witnesses, and you'd all be joined in by the court and put on hold. But as I say, different courts have different practices, and it does appear that sometimes the applicant or the claimant will be seized with organising a hearing, and likewise, sometimes you'll be invited to use technologies which aren't now the court's norm. So as I said right at the start, repeat my health warning. It's very fluid as to how this is all happening in practice. When the lockdown first happened, the court issued a remote hearing protocol, which I summarised here to the key parts. Some of the parts are overtaken by developments since. So, for example, there was a heavy emphasis at paragraph 7 on the legal issues to be addressed before any remote hearing can begin. But they're addressed, as I'll show you in a moment, by CPR 51Y and other paragraphs of the protocol. So the court will normally record, and during a pandemic need to have in private ought not to be a barrier to a hearing. Again, at paragraph 13, the initial guidance was a variety of possible platforms. Interestingly, at paragraph 16, it identified 3 ways forward in most cases to be proposed by a court: a stated appropriate remote communication method. Secondly, that the case will proceed in court with appropriate precautions. Or third, that the case will be adjourned because a remote hearing is not possible and the length of the hearing combined with a number of parties, overseas parties, etc., makes it undesirable to go ahead. Well, I think we moved quickly past attendances in person, so the second option. So it really falls between dealing with hearings remotely or an adjournment. And the guidance went on to deal in particular, as Ben touched upon, with some additional guidance in relation to electronic bundle of documents. And the guidance tells you that you need a PDF bundle of documents, an electric bundle of authorities for each remote hearing. And my hearing on Thursday, there's a single PDF bundle. It's going to be about 800 pages. It's going to be interesting to see how it goes. And I'm going to agree with counsel for my opponent that we agree an authorities bundle and we use our tech to gear that together. So that was the initial guidance from the court. We then had the inception of CPR 51Y, which effectively is an enabling provision which allows matters to proceed remotely. And although it's got some peculiarities, a little bit clumsily drafted in parts, fundamentally it enables hearings to take place via video. And in most cases, the courts aren't going to use the need for proceedings that happen in private or public as a barrier to dealing with things by video. We then have at the next update, 9th of April 2020. We're emailed this as a Chambers. It's signed off by various Lord Justices and the Lord Chief Justice himself. This I've just again screenshot. I hope you can all see it okay. I'm struggling slightly with my eyesight on it, but actually it gives some general pointers as to when a hearing might be able to proceed remotely. So we know right at the outset, we looked at the civil court priorities list, but it identifies at A that if one party opposes a remotely conducted final hearing, that will be a powerful factor in not proceeding with a remote hearing. And I have to say, at this early stage, one would think that you're entitled to take that stance, particularly where there's credibility issues at play, or there's some complexity, which means that actually dealing with the hearing remotely will be too unwieldy. So I think you're quite entitled as a claimant or defendant to say, well, actually, you're testing my honesty, or I'm testing your honesty, challenge an X, Y, or Z, we oppose it. And that's a powerful factor. Then it B, where the final hearing is conducted on the basis of submissions only and no evidence, it could be conducted remotely. Well, that speaks for itself. Video Skype hearings are likely to be more effective than telephone. And well, again, that speaks for itself in terms of the assessment of witness evidence. And parties should be told in plain terms at the start of the hearing that there's a court hearing and they must behave accordingly. Now, I won't stand up because I'm just wearing shorts underneath my shirt, but effectively you're told you need a neutral background, no eating or drinking unless it's water, and you've got to have your normal court hat on or we'll all be in trouble. There was then some further specific guidance given in relation to civil cases in particular. Listed remains a matter for the judge. He or she should not feel under any pressure to list a certain number of remote hearings every day. The best guide to what should be dealt with over the coming weeks is set out in the civil listing priorities. Well, we've already looked at that. And then finally, particularly careful consideration we need to give into any remote hearings involving litigants in person or persons, witnesses for whom English is not their first language. And that speaks for itself in a certain respect, doesn't it? So that's the guidance we've had from the court, which says actually that the court isn't just going to list these matters for the sake of it. Now, I've got to say that one of my trials this week isn't particularly urgent. It wouldn't seem to satisfy the requirements of the civil court listing priorities, but it's in there, and that's probably because it's the sort of hearing which can go ahead because it is straightforward. The other hearing, we filed a consent order with Central London County Court saying we both want it dealt with in person in 3 months' time. The claimant, Dimmick himself, has a computer or a device with a video link, and Central London County Court have told us somebody will probably look at it by Wednesday. I know you'll all be taken by surprise by the lack of efficiency at Central London County Court, but there we are. Sorry, I'm going through fairly quickly. I'm conscious I've run over my time limit. When I first drafted this PowerPoint, it said I can't find the QBD guidance anywhere. It's now on the operational summary link in the gov.uk link at the start. Various masters have produced their own guidance as to it, and no doubt if you have something listed in the Queen's Bench division that they'll take that approach. Again, it's an approach led by being sensible. Parties agree to adjourn any listed hearings because they're not urgent. The court's likely to let them be adjourned. Likewise, if you do need to adjourn something, as I covered in one of the later PowerPoints, the court is likely to waive any adjournment fee. In terms of filing and bundles, I've set out some summaries there of what's in the guidance. Skeleton argument should not be included in the electronic hearing bundle and instead should be emailed separately. So there you're sending your bundles and you're sending skeleton arguments separately. There are various specific rules relating to the High Court contingency plan in terms of what's open and what's not open. So, I mean, that's an overview of what we know in terms of the overriding guidance. A number of court centres have issued local guidance. I've summarised some of that there. I know that Plymouth is now starting to list things, and presumably Exeter is starting to list things by video for multi-track trial. So that's starting to happen. I know that members of chambers have conducted trials remotely on the Western Circuit since the lockdown. James, who's just spoken, I think did a credit hire trial remotely by telephone at Bath County Court last week. So the courts are seemingly getting on top of it. Bristol hasn't issued any general overarching guidance. So, for example, some of the courts in the Northwest and the Midlands have done. So Liverpool, Manchester, Birmingham have very much quite strong local guidance on what hearings are going to take place, how they'll take place, and what's getting adjourned or not adjourned. So if you do have hearings in any of those court centres, it's well worth checking that local guidance. I'd be really surprised if the court office didn't actually send you that guidance in their sort of covering email as to whether something's going to stay listed or not. And the final point I make, just there are many cases, and for example, clinical negligence cases with frontline clinicians. I had a PTR trial vacated last week. Frontline clinicians for the defendant simply couldn't get to trial. The court's not going to take a harsh stance on that. They're being sensible. And obviously cases with vulnerable parties and or dishonesty concerns are probably unsuitable for remote hearing. And it will remain to be seen the extent to which trials will be forced upon parties which aren't particularly suitable. So we'll wait to see on that front. Okay, well, that's a brief overview of remote hearings and how it's happening. I'm sure actually in the questions we'll be able to pick up any particular queries. That was an overview because, I mean, obviously we don't really have the time to go through each point in great detail for now, but please drop me a line if you've got any particular queries. The next section, which I can deal with pretty briefly, is COVID extensions and 51ZA. So this is another practice direction. This is the practice direction, you'll all have heard of it. It amends CPR 3.84. That's the provision which it's often inserted in your standard CCMC orders, which allows the parties to extend the time for compliance with any direction by up to 28 days, so long as any court hearing isn't jeopardised. Well, it's extended to 56 days under the COVID amendment to the CPR, incepted as of the 2nd of April 2020. That's very clear. Paragraph 2, you read it as 56 days. interesting point which I've had raised is, does that apply to defences? Obviously, Part 15 has specific provisions in relation to the extension of time for the filing of a defence. The prevailing consensus is that this COVID 51ZA does apply to defences, because obviously Part 15 provides a time for compliance and a sanction in the event of non-compliance, namely the entitlement of a party to enter default judgment against you. So I'll be surprised if somebody takes the point, but I read this as applying to all usual time limits, as well as the time limits for defences. If you need further time beyond 56 days, you need the permission of the court. That will be dealt with as a paper exercise. Any order made on the papers must on application be reconsidered at a hearing. So two circumstances come to mind. Parties have consented to an extension, the court rejects it on the papers. You'll have a hearing to deal with it. Obviously, if the matter's contested and the application's determined one way or another, you'll be entitled to be reconsidered for a hearing. And actually, an important amendment at the bottom of 4, and you can obviously read this into the relief from sanction provisions. Insofar as compatible with the proper administration of justice, the court will take into account the impact of the COVID-19 pandemic when considering applications for the extension of time for compliance with directions, the adjournment of hearings and applications for relief from sanctions. I suspect if you needed to make an application for relief at this stage, you'll find a benevolent court. I think Rachel Seagull later on in the series of webinars are going to do a full talk on relief from sanctions, so I'll keep my powder dry for now. The approach I've seen from both sides is conciliatory so far. What there isn't so far is any general limitation amnesty imposed by the rules. It will be interesting to see the interaction with the circumstances for extensions under section 33 in due course. One would think that 51ZA4 will be a gateway for that. But in terms of limitation, we do have the ABI agreement. I just read earlier today that there's an increased number of firms of solicitors. Some of you may work for firms of solicitors who have agreed to abide by the protocol, and I think there's over 100 insurers now who also will comply with it. And effectively, well, I've set it out there. There's an agreement that all limitation dates in all personal injury cases are frozen, and claimants undertake to respond constructively to defendant requests. I mean, a lot of you, especially on the defendant side, will be very, very familiar with this. And there's escalation processes if there's any sticking point. And obviously, if it comes to a point, whether you're claiming to defendant and you need to make a protective application, or whether or not you have or protectively issue proceedings, whether or not you have this agreement, you can rely on the practice direction at 51ZA. And I think you're going to be protected on cost if there's no limitation amnesty agreed and you're forced to issue protectively, whereas otherwise you would have wanted to agree a standstill. I think you're on firm ground in terms of costs. So that's where we are on limitation. We are waiting to see whether or not there'll be any more extensive provisions enacted in due course to deal with limitation. Again, one would feel that section 33 is going to be the tool in personal injury cases. My final slide is just COVID other matters. Electronic signatures, there's guidance on the Law Society website. I'm going to point you towards it in terms of when, how and if you can use electronic signatures. Yes, you can, is the short answer. But what is an electronic signature? Look at the Law Society guidance, it's very helpful. Medical examinations, there were some early reported cases where permission was granted for video examination. Obviously, there'll be, whether it's an orthopedic case or otherwise, there'll be some cases which just simply aren't suited to video examination, but Medco's lifted their ban on it for now, as from the 24th of March 2020. There'll be inevitable delays, likewise with disclosure of medical records, and I'm going to read this verbatim, which will not be deemed a priority task by the healthcare sector at this time. So I think we're going to see a general slowing. My own experience is that it's focused the parties' minds on on things like JSMs, virtual roundtable meetings, and the JSMs I've conducted remotely have gone relatively smoothly. And in fact, there's There's a bit less of the posturing you might see when you're in opposite rooms in, say, chambers. So I found it quite an efficient way of actually getting a good outcome. And then very finally, in terms of court fees, court staff have a discretion to waive a fee for an adjournment sought by the parties. So if you do need an adjournment, whether it's contested or not, don't write out your cheque for 255 just yet. That was a whistle-stop tour of COVID-19 practice and procedure. I'm just going to come out of sharing my screen, hopefully. Thank you, everyone. I think are we going to have the question and answer session now? Well, it wasn't ever going to go completely smoothly, was it? Ben, do you want to field one of these questions? Can I introduce you?
Hi everyone. You may have noticed that the Q&A bar has been open throughout this. And while the other two have been doing their bits, I've been sort of squirreling away trying to answer what I could. So some really interesting questions have been asked, actually. We were asked who's the best person to contact if you want to run a mock virtual trial. Contact seminars at stjohnschambers.co.uk. We've got a dedicated email address for that and similar seminar-related requests. We were asked about whether the changes to statements of truth apply to clinical and medical reports. I thought no, and Emma Zeb helpfully nudged me and said she thinks the same thing. So the wording to experts' report statements of truth remains as before, but actually you will notice if you look at the rules that part 20, that at the end of that specimen statements of truth, there is specific reference to part 22 and rule 32.14, which sets out the consequences of verifying a document containing a false statement. So the fact that it hasn't changed isn't likely to be material. It looks like there is a sort of broad tightening up towards the attitude of the judges, really, of the courts, to people who are found to have falsely signed a document or falsely verified a document. There's the whole list of these questions is there at the side of your screens if you want to look at them. One of the questions that's just been asked at the end, in fact a couple of them, one related to the costs of a failed virtual hearing if a party's been ordered to set it up and it goes wrong. I don't know if either of James or James have anything they want to say about that. My view is it's going to be case specific, and you'll need pretty clear evidence that the fault is with a particular party. The courts are going to be realistic and realise that these sort of things are prone to, well, as technology is, just prone to failure. And I think they'll be pretty sympathetic. So I think there'll have to be pretty clear evidence of what the fault was and that it was party X or Y that was to blame. I was asked about professional PDF editing software and any recommendations. That could be a long conversation, frankly. I've done a sort of brief précis there. I personally use PDF Expert. Basically, contact me, I think. If you want to talk about this in detail, I'm more than happy to. We've had long discussions about it in chambers, and it's not a straightforward answer. But I was really interested by this final question, which I just started answering, and I'm not sure what the answer is. So I'd be really interested to hear what the Jameses say about this. But the question from Sarah Middleton was that presumably witnesses need to see the bundle or parts of the bundle. Presumably this is at a hearing. The answer to that is, of course, they will. And how does that sit with GDPR requirements? What is the position regarding publicity of materials? Do we suggest emailing the witness just certain parts of the bundle, i.e. their statements, perhaps some exhibits or plans and documents that might be relevant to them? Or leave this to screen sharing on the day? And she assumes the witness shouldn't receive the entire bundle. I think that's a really interesting question. My sort of default view is that actually the witnesses would have the bundle, because you can't really tie the hands of certainly other parties' counsel as to what they might want to ask about a particular page in a particular bundle. But I can see the difficulty if there are sensitive medical records or something like that in there. So anyway, I wonder if either of the Jameses want to step in or have any thoughts about that. They're looking at me blankly. No, Hughes does.
My instinct is that if, as long, Sarah, as the bundle is distributed to the witness, and then that it is seen and can only be seen by that is the lawyers and witnesses and the judge, so only those people at trial who would have access to it, unless there's been any other previous argument about GDPR and sensitive or confidential information. But if it's in an agreed trial bundle, and as Ben says, the witness was going to be able to see or be allowed to see the rest of the bundle, I don't think there's a problem with that. I think Ben's instinct is right, because it's something which was going to happen anyway. I can see why you're twitchy about it, though. But it short is I agree with Ben.
Thanks, James. A couple of other questions that have come through just very recently. If limitation expires today, is limitation frozen until after COVID-19 settles? Is there any guidance on when the limitation will now expire? I'm putting myself on the spot here. There was certainly a sort of memorandum of understanding between certain insurers and an awful lot of the claimants' organisations, such as APIL, that dealt with the freezing of limitation. And I can't off the top of my head recall if it was automatic or whether it was a sort of open willingness to agree to reasonable requests for that. Given that it's just been asked and I'm not 100% of what the answer is, I can see why that might be really important. I wonder if whoever asks me that wants to get in touch with me or any of us separately afterwards. James Marwick or James Hughes might know the answer to that off the top of their head. James Marwick, if you can see that, it's the question about limitation. Can you see that?
There would be.
While you're thinking about that, the other question was, what is the position if a party has been ordered to set up a trial via Skype for business, but failed to download the software in time, resulting in an application to vacate? I have to say, it strikes me that if the order was clear that you are going to be doing it this way, one of the obvious steps you'd have to, you'd have to just take steps to make sure you could do it. And if the answer really is as clear as that the hearing was vacated because they'd failed to download the software in good time, then I think there's a good argument for costs against that person or firm. But it seems to me this question must be asked by the people who've made the application to vacate. And I suppose the question there is, well, how much time do you really need? The response might be, well, we were quite comfortable with what we'd done. We were going to be ready to go when the hearing date was due. So I can see that there might be sort of room for misunderstanding from the people who are setting it up on the one hand, who might know how much time you need and are quite comfortable that you can leave it quite late, and the people on the other side of the fence who perhaps might not know how long you need might understandably get twitchy and therefore make the application. And I can see that the judge hearing the application might have to first make a determination of, can the hearing in fact go ahead, i.e. can we set it up now at the last minute? And then a question of whether your sort of twitchiness about it was reasonable or not, and whether the sort of correspondence between solicitors was all it should have been. So I know that's sort of a heavily caveated answer, but I think as ever these are quite difficult to answer in précis. Marek, have you got an answer for that limitation thing?
Yes, it ought to be frozen. In terms of guidance on when limitation will now am I on mute?
You're now live.
I'm on now. I'm live. It should automatically be frozen. In terms of guidance on when limitation will now expire, the ABI protocol has been extended up until I think the 20th of May and it's been constantly reviewed. So I think ultimately there'll be some guidance which says effectively it's going to be treated as a standstill for this period. There'll be a notice of termination effectively of it to say the COVID-19 limitation protocol will expire as at this date in 2 months, hence say if you need to issue particularly, you'll have to do it up to that point.
Thanks, James. Questions are sort of pouring in now, which is great. I guess it means that a lot of you were just, avidly fixed to the screen while we were talking. But it does mean that actually there's quite a lot of stuff here to think about. Some of it related. Someone made a comment about witness bundles who said that the whole bundle should go to a witness. I think that's probably right. I'm uncomfortable with the idea that a witness might only have some of the documents, and I don't think the answer can be we didn't want to send them stuff that was sensitive. I think probably the answer is upriver of that. You're being careful when you're preparing the bundles and agreeing what should go in them. If you've agreed you've agreed what the contents of the bundle are and it's finalised, I think actually it has to go to all of the witnesses, because I just think otherwise the trial could become unworkable. There was a question about guidance on the court sending orders by email as opposed to by post. Some orders are not being received in good time. I don't know about that. I don't know if either of you know anything about that. By all means, get in touch with us after this by email. We have the hotline as well. These are specifically for these kind of things. If they require a bit of thought and we can't answer immediately, then that's the forum. I'm sorry, I can't answer that one immediately. If the court asks the parties to set up the hearing but they don't have the technology yet, is that a good enough reason to say no to a judge? Probably not. Probably not is my gut feeling. You need to get on with it and get the technology, I'd have thought. Of course, it depends. Are we talking software or hardware? There is always going to be some room for sympathy here, but I think the answer just has to be, if you've got any problems, get in touch with the court ASAP and speak to them about it, keeping everyone informed. Does anyone have anything they might want to say about those questions? Show me a thumbs up. Shake your heads. Okay, I think that's probably as far as we're going to get now. I'm conscious of time. We've been an hour and 15 minutes now. Brilliant, very helpful comment on the point James was dealing with relimitation. There's a further joint review of that position on the 13th of May. And another great comment here about bundle disclosure. Would it be sensible to request all parties sign an undertaking that they won't disclose anything they shouldn't do outside of those proceedings? I can see why that would be very sensible if the parties are willing to do that. So that's one potential answer. And I think probably we should draw a line there. If anyone has any further questions, they want to get in touch with us about anything else, please do. It's what we're here for. Unless anyone shows me otherwise, I will say goodbye and thank you very much for your time.